Foreign Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is a U.S.-based service provider offering IP docketing, paralegal, analytics, and annuity services. The SLW Institute is an educational group created by the Schwegman, Lundberg, Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together experts to talk about strategies and best practices for patenting in key foreign countries. The Foreign Excellence webinar series is free. This is the fourth one of several monthly webinars. The schedule and registration information for upcoming webinars in this series is listed on our website. To register for future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar we are presenting today will cover Canada, and I apologize, our slides jumped while I was doing my introduction. I'm going back to get back to the beginning here. Giles, I seem to be having some, there we go, thank you. Anyway, we've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the control panel that's on the right side of your browser window. You can submit a question at any time, but we're going to wait until the end of the presentation to respond to the questions. The presenters today are myself and Daphne Laneson. Daphne's from Smart & Bigger in Ottawa, and I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 20 years, and I also was a full-time law professor at Franklin Pierce Law Center in Concord, New Hampshire for 5 years. Daphne, tell us a little bit about your background.
Thanks, Anne. So I'm a partner at Smart & Bigger. My practice is largely in the chemical, pharmaceutical, procurement space. I've been at Smart & Bigger for my entire career, and I'm really happy to be joining you today.
Well, thank you very much for presenting today. Today we'll be discussing various aspects of patenting in Canada. First, I'm going to look at some data and filing trends for Canada, and then Daphne will talk about the patent prosecution process in Canada. The first slide that we're looking at shows some market comparisons just as a backdrop for our discussion. The first 4 countries are countries that we have discussed on previous Foreign Excellence webinars. The U.S. has the largest economy in the world, followed by China and then Japan. The Canadian economy is larger than the Korean economy based on GDP. And Giles, again, my slides are jumping, and I didn't touch anything. There we go. As I was saying, you can see here the Canadian economy is a little larger than the Korean economy, at least based on GDP, if you're looking at it that way. The countries of, well, Canada, like the US and Japan, you can see has a very service-based economy. Let's take a look at the patent filing trends. So first, looking at this by technology, this slide shows the top 10 technology areas for patent applications filed in Canada by any organization, whether they're Canadian or non-Canadian. Later I have some slides that will be broken down by resident versus non-resident, but this is across the board, just technology areas for applications filed in Canada. The top technology area is computer technology, which accounts for 9% of the filings. That's followed by digital communication, which accounts for more than 8% of the applications filed in Canada. So clearly, just looking at the top 2 and the remainder of the list, companies in the computer and electronics area are regularly filing in Canada. Next, looking at the top patent assignees based on patents granted in 2016, we can see that Research in Motion, which is now called BlackBerry Limited, had the highest number of patents granted in Canada in 2016. And we all know BlackBerry as the former developer of the BlackBerry smartphone. But since then, I think it's transitioned to more of an enterprise software and services company, and it received over 700 patents in 2016. Then the next 14 companies, the remainder of the ones on the chart that we're looking at, relative to BlackBerry's number of patents, are all relatively close to each other, or they're within about 125 patents of each other. Boeing, the second highest, received 259 patents in Canada in 2016, and it's followed by companies like Halliburton, Microsoft, Apple, Qualcomm. So again, this is a country that large electronics companies certainly file in, and Daphne, I know you're in a different technology area, and I'm sure you see stuff on the other side, but looking at the trends here, some of the highest filers tend to be in the high-tech area. Next, I was going to look at patent filings, but Giles, my slide is missing the data on it, so let's move on to the next one. Okay, let's skip that. Let's go to patent grants. Here the data is broken down by non-residents. So I think it's interesting to take a look at what other non-Canadian companies, or what are the trends for non-Canadian companies filing in Canada. So when we use the term resident and non-resident, resident is used for filings made by applicants in their home patent office in their home country. And then the term non-resident, which we're looking at in our data here, relates to someone who's filing in a foreign office. So the next slides look at grants based on non-residents. And again, this is comparing the countries that we've been looking at in our previous webinars to see in those countries how many, which countries are non-residents likely to be filing in. And clearly here, the number of non-residents filing in the countries of China, Japan, Korea, and Canada, it's the highest in China, but also quite a few in Japan, Korea, and Canada. The thing I think is interesting on this slide is the increase that you see in Canada, and in 2016 it's getting to be very, very close to the number of patents granted to non-residents in Canada as it is in Korea. Those lines are getting very close there. And remember from my earlier slide with the market data, the Canadian economy is also larger than the Korean economy, based at least on measures of GDP. Next, looking at just general patents in force in each of these countries. The number of patents in force in in the top three, China, Japan, and Korea, you can see has increased over the last 5 years, with Japan actually very dramatically increasing. It's interesting that the Canadian bar, or the Canadian line, over this 5-year period has stayed more level. While it has increased, it hasn't increased quite to the degree that the number of patents in force have increased in the other countries we've looked at so far, China, Japan, and Korea. Finally, the last thing that we've looked at in this series is the cost of a patent in each of these countries over the life of the patent. In this instance, at least with the data that we're using, which is based on information from a commercial tool called Global IP Estimator, it makes the cost of a patent look similar in Canada to the cost of a patent in China, Japan, and Korea. But I think that seems a little high based on my own personal experience, particularly the value of 17,000 US dollars, and this is all in US dollars. The amount of 17,000 US dollars for annuity payments over the lifetime of a patent in Canada, I think is a little bit high. I did a little of my own research just with people here at Black Hills IP, and the estimate on our end was that the cost for annuities was probably more in the 8,000 to 8,500 US dollars over the lifetime of a patent, that number would be more realistic than the 17,000 for annuities in Canada that my other data is showing. Daphne, would you agree that those numbers, at least on the annuities, look a little high for Canada?
I agree. So our data is comparable to your information. It's around $9,000, $9,200 Canadian, so completely consistent.
Yeah, so that would make it quite a bit cheaper to get a patent and maintain it for the life of the patent in Canada than in China, Japan, or Korea, just for the comparison of those four countries. At this point, Daphne, I'm going to turn it over to you to let us know how things are going in Canada.
Sure. Thanks very much, Anne. So before I try and leave the audience with some practice tips on patenting in Canada, I wanted to start with some good news stories from 2017. So last year was one of the more significant years for patenting and for patentees in Canada. We had some of the biggest decisions in at least the last 20 years come from our courts. And probably one of the biggest decisions was the Supreme Court of Canada that struck down a law that has been the burden of many patentees for almost 15 years. So for those of you who have been prosecuting and litigating in Canada, there was a standard for utility to show that your invention worked, which was very onerous, where your invention may be held to any promise or potential promise of utility in the description. And with the AstraZeneca decision, the promise doctrine was struck down, which was a real victory for patentees, both in terms of procuring rights and then also trying to enforce their rights. The promise doctrine and the utility law really was a very difficult hurdle for most to overcome. The other significant decision was from a remedy side, where the decision in Dow and Nova in a patent infringement case was the largest monetary remedy in Canadian history. And I think the value approximating some of the US values and maybe exceeding some of the US patent awards in recent years. It was almost $650 million in a remedy. So it's Canadian dollars, but still that's pretty good. And then finally, we saw some movement for pharmaceutical patentees where there was a couple of big gains. One was related to supplementary protection. So most jurisdictions have a way to restore lost patent term due to regulatory delays. Canada did not until September of last year. And then supplementary protection came in to restore now patent term for patentees for up to 2 years. There is also a change related to our patent linkage laws, where we now have a system that is much more aligned to what you would see in US ANDA litigation. So that too is very positive, I think, for patentees, and hopefully will create more certainty in litigation. So moving on to why Canada. Our closest trading partner is the US, and so we often compare ourselves to the US. If you were to look at patent procurement, our system, I think, is relatively cheap, in large part because our procedures are much more streamlined. So for instance, we don't have a continuation practice or continuations in part. We also don't have the ability to request continued examination, and also examiners do not, and the examination practice does not put us in a position where we would need something like that. And I think, generally fairly fast, and there are good tools that we'll talk about for managing prosecution. Another big difference is we don't have post-grant opposition practice. And so I know so many people have been tied up in respect of IPRs and the like. And so for us, we just have a re-examination practice, which is similar to what you had in the US in terms of ex parte re-exam. And really, most people, if they want to knock out a patent, will look at seeking a judicial remedy, because our patent litigation process is also fairly cheap when compared to the US, and it can be quite fast. So it's possible you can get to trial within 2 years. So I'm going to move on now to some more practical tips in terms of filing in Canada and some things to keep in mind. So something that changed a few years ago, but we still get questions about this, is whether or not you need to file assignments. In Canada, with rule changes, it's not necessary to file inventor assignments. And so all that's needed is a declaration of legal representative. If you're filing in the PCT and you're entering in the Canadian national phase, then we can rely on the declaration of entitlement that was filed in the international phase, providing it's in English or French. And so for most US applicants, of course, that's not an issue whatsoever. And so some companies will continue to file inventor assignments because they want to have a clear chain of title at the Patent Office, but the Patent Office is not going to ask for that. We also don't have excess claims fees. Now, we do have fees when you pay the issue fee, that if your patent specification is over 100 pages, then each page is an additional $6. But that doesn't catch very many applicants. And so when you're looking at Canada, there's no need on filing to try and reduce the number of claims in your application. And during prosecution, you can add as many claims as you really wish, no issues with multiple claim dependencies. Another practice tip, although this is set to change in about a year, is that national phase entry is 30 months, as with most countries, but there's also a further 12 months that you can buy with a late entry fee. So it's possible you could enter PCT national phase by up to 42 months. Now, I said that this may be changing. So there is a proposed change to the patent rules that is going to affect a number of our procedures, including national phase entry or late entry. And so we're looking probably at the beginning of 2019, where if you miss the 30-month date, and you want to file within 42 months, you will probably have to show that but for due care, you would have not missed the date. So you had taken all necessary steps, but you still missed the 30-month date and now need to enter late. So those rules are not in place at this time, but we are expecting this change to come into effect early in 2019. And then finally, grace period. So we do have an applicant-derived public disclosure grace period of up to 1 year from the Canadian or PCT filing date. So applicant is quite broad. It's not just inventor-derived. It can be anyone related to the applicant entity. And the other trick, though, is it's not tied to the priority date. So you do not get to go 1 year before your US provisional date. It has to be 1 year before the Canadian or PCT filing date, that disclosure. And if it's within that 1 year period, then you're safe from that being a public disclosure that's going to bar patentability. So on the next slide, I wanted to touch on a few major steps in prosecution. One of them is the requirement for annual maintenance fees. So those are due each year, starting with the second anniversary. The request for examination, 5 years from PCT or Canadian filing. The proposed rules that I mentioned is looking to reduce that to 3 years post-filing, but it's still a lengthy period of time that may allow you to secure grant in some other jurisdictions that might be helpful in terms of advancing Canadian prosecution, or at least focusing the applicant on the claims and arguments that they wish to make during prosecution. Now, typically you have 6 months to reply to an examiner's requisition, unless the case is under a special order for advanced examination, and then it's 3 months. But our proposed rules are looking at reducing the 6-month term to 4 months, but that should hopefully be sufficient time in order to put something together. So there's a fairly liberal timeline in terms of responding to an examiner's report. With grant, your issue fee is going to be due within 6 months from the notice of allowance, but once you pay that fee, you're probably going to have grant within about 6 weeks post-fee payment. Now that's relevant because if you are filing a divisional, for instance, the divisional has to be filed prior to grant of the parent. So typically you want to be filing your divisional when you pay your issue fee to make sure that the divisional is actually on file before the patent grants, because that 6-week period can go by pretty quickly. So turning to the next slide and amendment practice. We have a fairly liberal way of dealing with amendments. So voluntary amendments can usually be made at any time up until allowance. And our new matter standard is quite similar to the US, so distinct from Europe. Amendments can be made that are reasonably inferable from the specification, which in Canada includes the description and the claims, and or drawings as originally filed. We also have a provision in our Act that if you admit subject matter forms part of the prior art, you can add it to your application. So this could be relevant, for instance, where you've incorporated by reference a prior art document. In Canada, we can't incorporate documents by reference, so you're going to need to remove the incorporation. But there may be subject matter in the document that you think could be relevant to sufficiency under Canadian law, so written description enablement. And in Canada, you can revise the description to add in that subject matter if you think it may be relevant to the patentability or validity of the application or patent. We also have an amendment after allowance practice. The current practice is that before paying the issue fee, you can make amendments that introduce further claims, for instance, providing that they do not necessitate a further search by the examiner and are otherwise compliant with the Act and rules. So you can add in, for example, dependent claims, generally, although potentially another independent claim of falling within the scope of the original claim or the allowed claims, or maybe of a different claim category, but a very similar scope. So for example, in my practice area, you might have a composition claim that includes use aspects and dependent claims, and you want to add in a use claim of the elements of the composition. So that could be possible. But if you want to add in further claims that need to be searched, our current practice is you would have to go into our abandonment reinstatement provisions. And so you wouldn't pay the issue fee, you would add in the subject matter on reinstatement, and reinstatement is as of right within 12 months after the act of abandonment. And that practice reopens prosecution and allows the examiner to consider the newly added claims. Now, with the proposed change in rules, the amendment after allowance practice will be such that all amendments will have to be made within the 6-month window, and they will go before the examiner, so effectively reopening prosecution with every amendment. I think in practice, it's not likely to change anything because for very minor amendments, the examiner is unlikely to raise any issues, and it will presumably just proceed through without a problem. So turning to the patent term, one key difference from the US is that we do not have patent term adjustment to deal with patent office delays. The good news is, and I have some slides on this, that the patent office right now has become pretty prompt at examining cases and moving things along, even without advanced examination. Now, as I mentioned, we recently put in place supplementary protection. So now for pharmaceutical products, there is the potential of up to 2 years for a certificate of supplementary protection. And this is very similar to Europe. Unfortunately, we didn't get the 5 years like Europe, and there's no pediatric extension to this term, but 2 years is better than 0, so we're happy about that. Now, I want to turn to some potential pitfalls that you can encounter during prosecution. And the two big ones, I think, are probably double patenting and statutory subject matter. Now, utility really had been the biggest issue facing patentees, I think, or many patentees. And with that law now being changed with the AstraZeneca decision, we're back to, I think, more standard issues. Although, as we go to the next slide, you'll see double patenting in Canada is a little different, I think, than in the US. We have, similar to the US, same invention and obviousness double patenting, but we do not have a terminal disclaimer practice. And so that can, of course, cause some problems. And where do we see these problems? Well, one of the cases where we see issues is with voluntary divisionals. So if a Canadian examiner raises a unity of invention objection and you make an election and you file a divisional to non-elective subject matter, there's no problem. That's not going to create a double patenting issue. Our Supreme Court many years ago said that a patentee effectively shouldn't be penalized for only doing what the Patent Office has told them they had to do. However, if you file a divisional based on your own election, so no objection by the Canadian examiner for unity, or you do something outside of the unity objection, you may run into double patenting problems. And so the advice is always to try and file and pursue all subject matter in the original application absent a unity objection. Another instance where we see problems arising is where closely related applications are filed on the same day. So from time to time, an applicant will file a first case, application 1, that maybe claims a composition of matter, and then on the same day, file application 2 that claims the method of use. And it's not uncommon that you may have a double patenting issue that might be raised as between the two cases. But if the examiner doesn't raise it, something to think about is whether or not you want to collapse the subject matter into a single application. If the examiner thinks there's a problem, he'll encourage you to do so. But if we see it, we will often suggest the same. Now, it could be that the method of use case is clearly patentably distinct from the composition of matter case, but in certain instances where you may have a cosmetic formulation for use as an anti-wrinkle cream, and then you have a method of using a cosmetic composition as an anti-wrinkle treatment, then those two cases are very close, and it would probably be very difficult to show that whatever the second case granting is, it's a different invention over the first. So in those instances, we would encourage trying to collapse them into one case. And typically the disclosures are the same in circumstances like that. Another possible problem arises where you filed a first case, your first US case, you file a Canadian application corresponding to it, there's a CIP filed, and then there's a new application filed in Canada based on the new subject matter added in the CIP. In a circumstance like this, they're not filed on the same day. The CIP invention should be a non-obvious invention over the original invention. So the tip here is to prosecute the cases so the first case grants first, and then the CIP-based case grants second. The way double patenting has been applied is that it's the second case to grant that must claim subject matter that is patentably distinct over the first case. And in most instances, the examiner will notice this during prosecution. We may notice it, but I think it's really important for applicants to be sensitive to this issue because it may get missed. And it could be that the second case somehow advances ahead of the first, particularly if they go to different examiners. So this is really, I think, important for applicants to be aware of that particular issue. So I want to move on to statutory subject matter. In Canada, we have not had a lot of law on this point, and for the most part, the law has been relatively favorable. We have a broad definition of statutory subject matter in our Patent Act. This probably looks familiar to U.S. attorneys because the Canadian definition was taken from an early version of the U.S. statute. We have statutory exclusions that exclude a mere scientific principle or abstract theorem. Our courts have said abstract ideas and professional skills and judgment are not patent eligible. And for many years, the focus was therefore on methods of medical treatment. We did have some cases involving what are called higher life forms, so the Harvard mouse, which was found not patent eligible, but we've also had cases finding that a cell, was patent eligible. And so typically in the biotech and chem space, we can often get around these issues. But a few years ago, and moving on to the next slide dealing with business methods, Amazon ran into a problem at the patent office with their one-click patent. And the patent office didn't want to grant this. Amazon decided to take it to the federal court, and the Federal Court of Appeal ultimately agreed with Amazon, finding that the subject matter was patent eligible. Now, they characterized it as a business method, and so that could be viewed as very positive, but the way they approached the issue is they looked at the claim as a whole, and they construed the claim using our standard principles of purposive construction. So looking to see what elements are essential, what elements are inessential or not essential to the working of the invention, and if the essential elements define something that's patent eligible, it should be patent eligible. So the court ended up sending this back to the patent office, saying they had used the wrong approach. The patent office promptly allowed the case issued to patent, and that Amazon case was done. Post-Amazon, the patent office issued a number of practice notices, and they adopted Amazon, but with a flourish. They supplemented the purposive construction approach by looking and taking a problem solution approach. So they seem to have pulled from European law to some extent. We don't have a problem solution approach really to any issue under Canadian jurisprudence, but the Patent Office adopted this. And the problem solution approach essentially is that neither can be merely an abstract idea or professional skills and judgment. Now, in my area, we see this periodically in terms of dosing regimes, where if there's a dosing regime, the physician needs to apply professional skills and judgment, and then that may be non-statutory. But if we move to the next slide, this issue does come up in other areas, of course, so computer implemented inventions and diagnostics. So when CIPO is looking at these issues, they should be considering what features of a claim are essential to the invention. So for example, if a feature such as a computer is essential to an invention, then a computer implemented invention should be considered patentable. The Patent Office may also require some element of physicality. So for example, a computer, or as I mentioned, a technical solution to a technical problem. So it's not just an abstract idea or professional skills and judgment. So in diagnostics, the problem will likely have to be construed as more than a data acquisition problem, or the solution will have to be more than a disembodied data analysis without any practical application. What we're seeing is some issues around diagnostics, although I don't think it's quite at the same place it is in the US. Often we can get something through the patent office, but we are expecting to see some changes on the diagnostic side. So there's been quite a bit of attention recently on the patent office and its approach, because of course there's no case law that would drive their current approach and current analysis. And so this is really a patent office defined theory of what's patent eligible, and under Canadian law, that's really not supposed to be the way it works. It should be based on the statute or based on the jurisprudence, and the Patent Office is really not in that kind of rule-making position. So I'd like to move on to look at some examination timelines and then ways that you can manage your grant. So I've included a slide that looks at the length of time it takes to the first substantive office action, as well as subsequent actions. And my experience, these timelines, particularly in chemistry, both organic and general, are quite generous. We're seeing patent first office actions in many cases in a year or slightly less than a year. And on second actions, it's not uncommon to have them issue within just a couple of months. And so the Patent Office, I think, has dealt with most of their backlog. And so you may actually see that in many cases, it's really not necessary to advance prosecution. But turning to the next slide, I've included some things to think about if you want to speed things up or slow things down. So you can accelerate prosecution in Canada by a few very simple things. One is to just request examination on filing or national phase entry, promptly replying to all office actions and paying fees quickly. But you can also look at a couple of other things. One of them is special order. With a special order, you essentially just have to pay a $500 government fee. The caveat, though, is that you can't have allowed your application to be abandoned or have requested an extension of time, which I think the government decided shows that you really didn't want to advance the case, so that precludes you from later trying to speed it up. But in many cases, this will be available, and it's available at any time. You could have a fourth office action and then request a special order. We also have a green technology special order, so limited to only certain green type inventions. This one doesn't have a government fee, and it's not used very often given the limitations on the subject matter. So it's more commonly the fee-based special order. But we have seen an uptick in PPH. So Canada is a member of the global PPH. There are 25 patent offices, including the USPTO. And then we also have bilateral agreements with Europe, Mexico, SIPO in China, and Chile. And we see quite a bit of interest on the EPO, PPH, and of course the USPTO, as well as Japan. And in my experience, it is quite effective. You do have to proceed down this road, though, before the examiner picks up the case. So typically we're asking or requesting a PPH with the request for exam or shortly thereafter. But for the most part, Canadian examiners are really abiding by the intent of this process, which is to not reproduce the search and examination that was done elsewhere. So sometimes there's new art that is raised, but it's not very common. Typically, it's just formality issues, some of which you might be able to address at the time of the PPH, but other issues which certain examiners don't like certain terminology, and of course you see then objections arising. You can also try and buy more time, of course, by deferring examination. Right now for the full 5 years, or when the rules change, it'll be 3 years. You can wait out your time for reply. And then, as I mentioned, there's abandonment reinstatement, where you have 1 year to reinstate as of right. There will be some instances, however, where in order to reinstate, you have to show that you had taken due care, but you still missed the deadline. So that is something that may change in early 2019. So I want to switch gears slightly and look at some highlights of Canadian patent litigation. So I tried to focus on a few things that are different as between Canada and the US. And a few things that are different pre-trial is that we have a more limited discovery than in the US. So you're looking at only having fact inventor experts be involved in the discovery and one representative per company. And so we do not see the broad discovery that you have in the US. And for that reason, that really does help to manage the cost of the litigation and also the timelines. And we also don't have forum shopping. And so because of this, it really does simplify matters as well, although I know things have changed in the US, so it's not quite the same way it used to be. In terms of trials, we don't have juries and we don't have Markman hearings, although the proposed changes to our patent linkage litigation would or potentially could allow for claim construction issues to be addressed before trial. But in a standard patent trial, you're not going to have that issue bifurcated. And we have remedies that are really quite consistent with the US in terms of damages and the equitable remedies of injunction or accounting of profits. And we also have costs available to the winning party. And so you'll have attorney's fees that you may be able to recover some of your costs. And then, of course, we don't have treble damages. And then finally, our standard of proof is balance of probabilities as opposed to clear and convincing evidence. And I think for the most part, the pendulum always swings when we see cases that or periods of time that seem to be a little more pro-patentee, and then other periods of time which seem to be a little less in favor of patentees. I think that with the law and utility changing, we're seeing cases again that are really quite favorable to patentees. So if you're a patentee, your chances of succeeding, I think, in Canada are generally quite high. So it is a favorable jurisdiction from that perspective. And that's really all I wanted to say on prosecution, and then some highlights on enforcement. So Anne, I think we have the floor is open now to some questions.
Right. So I just want to remind the audience that questions can be submitted with the question box on the control panel on the right side of your browser. If you have questions generally about Black Hills IP and our services, please contact our Vice President of Sales, Jim Brophy, whose contact information is on the slide. If you want more information about the SLW Institute, please contact their Program Director, Brian Ness. And let's take a look. We have a question that, Daphne, I'm going to direct to you.
Okay.
So this is kind of funny because I was sitting and listening to you talk, and I thought, wow, I want to practice in Canada. There's no assignment requirements. There's no excess claim fees. I can make voluntary amendments about any time I want. The new matter standard is pretty low, and the office is pretty prompt. You got like a great place to practice.
Yes.
So the question here is there a path, and I'm not the one asking the question, somebody else is there a path for U.S. registered patent practitioners to become registered to practice in Canada?
Good question. There are reciprocal agreements between the offices, and so U.S. attorneys could get a Canadian registration number. I haven't looked at this in quite some time, and I believe there are certain issues in terms of having some kind of residency up here. But that is in our patent rules, and the patent office actually is probably a good place also to start because I don't know all the details about that. But that's one that is a possibility. And then of course, if you move to Canada, then you would be writing, in order to practice fully up here, you'd be writing the agency exams. And so there would be a period where you have to be working under a Canadian licensed agent and writing our agency exams. The reciprocal agreements between the offices provide a fairly, I think, limited set of rights before each office. And so to fully practice for any applicant in Canada would be writing the exams. And for some reason, I do think there is some kind of residency associated if you wanted to be practicing in Canada.
Okay. The next question relates to prior art and submission of prior art. Is it the case that an applicant is only required to submit prior art references upon request from the examiner?
So that yes, technically yes. So we have well, actually I shouldn't say that. I said yes and no. So there is a requisition that the examiner can make requesting prior art information, and you have to reply in good faith to that requisition, and if you don't, your application is abandoned. There's also a general good faith requirement when responding to an examiner's report. And the case law is such that if you're aware of a reference that may be, for instance, more material, using US terms, or any kind of fact or law point of law that would not be known to the examiner but may be relevant to the Canadian prosecution, then to comply with the good faith requirement, it would be our advice to disclose that to the Patent Office. Now, there have been challenges over the years to try and expand that requirement, and there had been a blip in our jurisprudence where people were trying to invalidate patents based on a lack of good faith in prosecution. And the courts, although this hasn't gone to the Supreme Court, the courts have said that essentially what happens in prosecution in terms of replying in good faith cannot then become a reason to invalidate a patent. There's another provision in the Patent Act dealing with a fraud on the Patent Office, but that has been applied in very narrow circumstances to date. So under the current law, our recommendation is that when replying to an examiner's requisition, you must reply to the examiner's specific requisition regarding prior art. But if you are aware of other facts or points of law that might be relevant, then our advice would be also to bring that forward to comply with the good faith requirement. But there's really no obligation that's in the Patent Act itself, the patent rules, and that the courts have found that would require you to be continually filing prior art with the Patent Office. That being said, many applicants just find it easier to file art with the Patent Office in Canada at the same time they're doing it in other jurisdictions, which is fine, but there's no requirement or specific requirement in the statute to do so if it's not when you're replying to an office action.
Okay. I have one more question, and that relates to your comment about the changes in the rules. You had talked about the fact that there was going to be a 2-year supplemental protection certificate, and I didn't catch, is that available now, or when does that become available as an option?
Sorry, yes, that is available now. As of September 21, it became available for pharmaceuticals that were approved after that date. So for products that were approved prior to September 21, it's unlikely there'd be any supplementary protection unless, for instance, there was a new combination of, for example, that active in one product with something else. There could be supplementary protection there, but the intent was for any new product going forward to have this process be or have this new form of protection available. There's one big I guess hurdle that companies are facing, and I'll mention it now, and that is Canada has included a requirement that in order to be able to get supplementary protection, you have to be filing your new drug submission, which is like the US new drug application, with Health Canada within 1 year of your earliest filing in the US or in Europe, Japan, Switzerland, or Australia. There is a transitional period that is probably not going to apply very often, so I won't even mention it. So most products, though, you're looking at filing within this 1 year. And that has proved to be actually a bit of a burden on companies because they might just not have the resources to do that. So in any case where it looks like supplementary protection may be available, it's good to ask. But if you're advising clients, if there's anyone listening who is in the pharma space, if you're advising clients on their global exclusivities, I think it's worth looking early at whether or not it's possible or what you want to do in Canada if it may be important to try and get this extra 2 years, which of course generally it is.
Okay, good. I don't know if you're going to be able to answer the next question, but I'm going to read it. Hello, I have lost patents to the U.S. DoD under secrecy orders. I'm a Canadian citizen, but I submitted my patents in the U.S. because I was living there. Does Canada also take patents for national secrecy reasons? And if so, what kind of recourse? Do you have any experience with that?
We do have certain technology generally related to military technology that would be deemed that it should be kept secret. There are not that many applications. And so if I do understand the question, there is a possibility that if you file an application in Canada, that it will be kept secret.
Okay, so there is a risk, albeit a small risk, I would think.
Yeah, I really don't think there are very many at all.
Yeah. Okay, now let me just check the question queue. I think that's all, and we're getting close to the end of our time anyway, so there we go. Just now want to let everybody know about our next webinar, which will focus on Mexico. It will be presented on Thursday, February 22nd at 1 p.m. Central Time. And Daphne, I want to thank you very much for your presentation today. It was very useful, and I learned some new things. I'm going to have to stop relying on that extra period of time to go into Canada at 42 months, I think, in about a year. So glad you warned me on that.
Thanks very much, Anne.
Yeah, thank you. You did a great job, and I want to thank our audience for listening today. We hope that you'll join us for this and other webinars in the future in the Foreign Excellence webinar series. Thank you, everyone.
Thank you, Anne. Bye.
Bye.